Hi, folks who have joined. Welcome. We're going to give just a couple minutes for more attendees to sign into our 32 BJ webinar. If you just joined the webinar, welcome. We're just going to wait another minute or two to let a couple more attendees join. All right, another 2 minutes and we'll get started. All right. Thank you all for attending. I'm Leah with the Daisy management team, and we've got Rob Schwartz here. Last week, the 32BJ deal reached a new deal for a 4-year residential contract. So we're going to be in conversation with Rob, who is the EVP and COO at the Realty Advisory Board on Labor Relations. He helped negotiate the contract on the employer side, and then at the end we'll jump into some of your questions. At any point, you can pop them into the Q&A below, and then we will get into them at the end. Thanks for being with us, Rob. Happy to have you.
Thanks for having me.
So before we dive in, could you maybe share what it was on-site employees were hoping to get out of the negotiations this year?
Sure. I mean, I can't really vouch for what each individual employee was looking for. I know it was generally more money, and their union demands were reflective of that. They also wanted to retain their access to no premium sharing for their healthcare, which is very good healthcare. And they had a couple of other what I would call, more policy-based concerns around immigration and around collective bargaining itself that they brought to the table.
Got it. So could you give a broad overview of what the changes were that were actually implemented in the contract?
Sure. To avoid burying the lead here, I'll give you the actual settlement of the contract, which is it's a $4.50 settlement over 4 years to your base level, your rank and file employees, which are your porters and your door persons and your concierges. It was $1.95 in benefits over those 4 years as well. It was an average 3.38% cost increase over 4 years. And if you weight that average, it drops to 3.01% over those 4 years. And what does that broadly mean? It means that currently your porters and your door persons under our contract were making a wage of 61,900, give or take. And by the end of this contract, we'll be making 71,200, give or take. Okay, so it's important to remember that the wages, though, are only two-thirds of this. One-third of this is the benefits. And if you add in the benefits and other costs and in terms of employment taxes and things that you pay for insurance, it's going to be over $125,000, almost $129,000 at the end of this contract for each porter or door person that you employ. So that's the big ticket item, the settlement, which we thought was considering the background that we're in financially, economically at the moment, with inflation rising and the union pointing out the fact that they had lost earning power over the past 4 years. A settlement that is around 3% is a very, very good settlement in this labor market. But in addition to that, there are a few other things which, if you ever want to bore yourself to death and go check out our website, you can read through yourself, but I will read you the highlights, which is they maintain access to no premium sharing healthcare. They have a very good health program. They also have a pension fund, which resulted in an increased pension benefit to the employees of 15% for those who were retiring after July 1 of 2026. But the even better news for employers is there was no additional contribution due from employers to fund that increased benefit. We will continue our steady course of increasing the contribution of $4 a week each year of the contract, as we have done for probably the past 20 years, though. The legal fund and the supplemental retirement savings plan and the training fund are the three remaining funds that we deal with 32BJ, and those saw no increases in terms of contributions. There's a couple of other more interesting sort of language changes, most of which are interesting only to lawyers, but I will give you the update in terms of what you should probably know. One important thing is union recognition and union security. This means when employees are hired into specific buildings, what do you have to do? Normally, it is the employee's obligation to join the union within 30 days of employment. And here we are making it easier for them to do so by giving them either a web link or a QR code that allows them to access their membership forms and go directly to 32BJ. And the even better news for us on that is there is no penalty if you forget to do it. We should use our best efforts to try and do so, though, as we do that under the contract. In terms of other things, sickness benefits, we agreed to give employees in their first year of employment 4 unpaid days for sick leave, and that is to bring us into compliance with New York City state sick leave law. And that is only in the first year of employment. There is a waiver in our agreement for the remainder of that law. And the benefits that they receive under our contract are, generally speaking, much better than what they would get under the plain New York City law. Other than that, there are a couple of side letters that are interesting. Side letters are a lawyer's way of making sure something stays out of the body of the contract. And it's kind of a test area where we like to maybe experiment a little. One of the big issues for the union this year was, no surprise, immigration. Many of the employees that we employ and many of the members of the union are here on different kinds of visas, different kinds of immigration statuses. And we agreed that we would establish joint trainings for the RAB and the union to teach employers sort of what their rights and obligations are should an enforcement action come to your building. And we also agreed that we would post a poster in the break room or wherever you would ordinarily post employment posters that gives employees access to attorneys at the legal fund that they already receive contributions for should they face any immigration enforcement matters. The other big change would be we established a pilot career track training program. And what this means is a newly hired employee into the industry generally has 42 months from when they start to when they reach the 100% wage rate, 21 months at 75% of that wage rate, and 21 months at 85% of that wage rate. And what we've said is this was really designed so that we could give experience to employees and they could gradually work their way up. So we designed essentially a pilot program for the first 2 years where employees in that new hire track could educate their way to a higher wage rate simply by taking either 30 hours or 60 hours of courses with the training fund on a course track that the employers and the union will agree upon. So for those employees who are really motivated, it's a chance for them to really move their careers forward. And the good news is
Great.
it's only a 2-year pilot program. We'll see how it goes, and then we will have a chance to modify it before it becomes a permanent fixture of the agreements, and we can tinker with what classes we want to make sure that our employees take. And that is pretty much the agreement in a nutshell.
Great. Thank you for taking us through that.
Sure.
So, a couple of questions. Um, it sounds like the increase on the dollar side is quite small, whereas the impact is much greater on the benefit side. If you're kind of your average condo co-op with, let's say, 2 to 3 union staff members, what does this contract mean from a financial perspective over the next 4 years?
From a financial perspective, what it means is your labor costs are going to go up about 3% on average over those next 4 years, which if you've been planning appropriately, and I know if you work with Daisy, you're planning appropriately, you were prepared for probably a 4% or even 5% increase, which was not out of the question in this round of bargaining. The 3% came in as we hoped. And, hopefully you're well prepared for that increase in labor costs.
Great. And the contract was officially ratified last week, if I'm not mistaken.
Correct.
But I believe we have a retroactive date in April, if that's correct. So what does this mean for buildings and boards?
So what this means is there will be an assent that goes out from the RAB to each of the employees, each of the employers who are under our agreement and who are members of the Realty Advisory Board. And you will sign the assent, which will bind you to the 2026 agreement. And once that's in effect, or even before that's in effect, if you know that you're going to sign an assent and there is no issue that you need to raise, you need to retroactively pay the employees from April 21st of 26 the increase on their hourly wage rate, which will be one check, a retro check. And then going forward, you should increase their wage rates and continue to pay them at the appropriate wage rates under the contract.
And as you said, if your property management company is doing what they're supposed to be doing, they should be handling this logistical work and be on top of this already.
Yes, and most of the vast majority of the people we work with are reaching out to us regularly to check and see what they should be doing. And the RAB is there as a resource to its members, and hopefully a pretty inexpensive one. At I think it's $112 or so per employee per year, and you get essentially representation in all of your labor and employment matters coming out of the contract, representation in grievances and arbitrations arising under the contract, and you can call us for daily advice and counsel for your employees under that contract.
Great. So if we take a step back, how do you think this will impact the market more broadly?
It's interesting to see because recently many employers were obligated to start paying prevailing wage if they wanted to make use of one of the many tax benefits available to them under state or city law. And we've seen a lot of former non-union buildings be forced to pay prevailing wage. Okay. And prevailing wage is based upon the RAB's contract with 32BJ, meaning the wage rates are the same wage rates, the benefits rates are the same benefits rates. But if you're not unionized, you're paying a supplemental rate, which is what we pay for benefits. You're paying that directly to your employees, and that is also taxed as employment taxes. Whereas if you're paying it to the benefit funds directly, you do receive the tax benefit that it is not taxable as a wage. Okay. The other benefit that you receive, though, is that the health fund and the other benefits we provide, generally speaking, are a pretty good bang for the buck. You get a very, very good program for health and pension and retirement planning that you just ordinarily, even with the same amount of money dedicated towards obtaining those benefits in the private market, you just wouldn't receive comparable.
Got it. So the TLDR there is that it probably makes sense to hire or encourage even your on-site team members to join the union, and that, as you just said, they get more bang from their buck from their benefits with no additional cost from the building if the building is trying to get that tax abatement.
Yeah, I mean, look, from the prevailing wage perspective, who passed the law that said, if you have a tax benefit, you had to pay prevailing wage? Well, that was a local 32BJ lobbying effort because they know they can then walk into those buildings, organize them, and it's an easier road for them if you're already paying that amount. Okay. The labor lawyer in me says, do you want a union building? The answer is maybe not. Okay. You should probably talk to a labor lawyer before you make that decision. But if you're already headed down the path for, prevailing wage, it is one of the more cost-effective ways of handling prevailing wage.
Makes sense. Good asterisk there. So I think you did cover anything. Is there anything else, maybe new staffing rules in buildings, anything that maybe you didn't cover that are now going to need to be implicated?
No,
Executed?
this is a 95-year-old contract essentially. The changes in how it operates are minimal, if any. And I went over, I guess, in brief, the onboarding of employees with handing out essentially a dues checkoff card and things like that. There weren't any substantive changes in the work rules other than new hires where you'll have to deal with unpaid sick days, and you'll have to deal with potentially them ramping up under the new training path.
Got it. Um, would you say that, as a board member, is there anything board should be, paying attention to as this contract is now live?
Yeah, you should be making sure that whoever is managing your payroll is managing it appropriately, making sure that the increases get put in, making sure that you're working in accordance with the contract. And if you have any questions, or if your payroll specialist has any questions, they're always free to reach out to us. And that's what we do day in and day out, is work people through problems with the union contract.
Do you think this is something that makes sense for boards or management companies to be communicating to unit owners?
It's sort of a mixed bag, is what I would say. You know, boards operate to run the building, to operate the building from an executive perspective, and you need to be careful as to what you communicate to shareholders, as you would in any other business. Okay, things that are important that directly impact the value of the building, things like the settlement of the contract, that we're not on a strike. Absolutely, you should be communicating those things. Specific strategies that you want to implement, though, I would say you should be having those conversations directly from a board level with your management and with your labor lawyer, whether that's me at the RAB or whoever you choose to use.
Makes sense. And is there anything that's not in this contract, but maybe on the horizon, that's being discussed that you think, could be coming down the pike?
Look, it's a steady drumbeat from us that it is unsustainable for us to bear 100% of the premium for health insurance for these employees. It is, in the neighborhood by the end of this contract, it will be almost $28,000 a year for healthcare for each employee. And that is, I got to say, for the plan they have, that's a great price. It's absolutely a great price, and their health, essentially goes up by like 4%, 3% every year, which if you're on the open market purchasing health insurance, what you're seeing is more along the lines of 6, 7, 8% per year increase in healthcare inflation. But there's going to come a point in time where they're going to have to contribute to the healthcare premiums. It just becomes unsustainable. And look, there are many topics of conversation that the union and the REB go through. We've been in this dance for, like I said, close to 95 years now. We know each other very well, and 32BJ is a very professionally run union. We're a very professional organization, and we tend to work out a lot of the problems ahead of time. And the benefit you have from RAB membership is you'll know what those problems are ahead of time, as well as we go into contract negotiation, and we set you up to prepare for those.
Got it. Um, and I heard something about a new minimum wage law for security guards that's being discussed in
There,
city council.
it's actually already passed. It's the Ayland Etienne Security Guard Minimum Wage Act, I believe is the full name of the law. Don't quote me on that. That's off the top of my head. Um, But what it intends essentially is to make a prevailing wage a minimum wage for security guards in New York City. And that law is not in effect yet and is currently subject to challenge by several, I think, property owners are underwriting the contest of the law as exceeding the powers of city council. And look, there's a law out there that says city council can't pass minimum wages, and it's probably about 100 years old, so we'll see if that law is still true. But at this moment, if you employ security guards, I would be keeping an eye on your legal news and talking to your labor lawyer. And if you're already under an RAB agreement, there's nothing to worry about. The minimum wage they want to impose is already the RAB security agreement. But if you operate non-union, or if you operate with an independent security contractor, you should have an ear to the ground in terms of changes that are coming down the pike.
Got it. Um, okay, so before we switch over to Q&A, if the board members take away only one thing from today, what do you think it should be?
If board members take away one thing, it's that you have an excellent established labor relationship with 32BJ. You have a contract that is well executed and it is well run, and costs go up, generally speaking, in a very reasonable manner, which is not always the case, I can tell you. As a 20 something year labor lawyer, sometimes you see a lot of costs come into contracts. And the RAB is there for you in terms of being able to answer questions you may have about this contract. It is a voice for you when we negotiate these contracts. And Daisy and we interact probably on a daily basis to talk about employee issues under this contract. these are the matters that you should keep in mind, both in terms of the RAB and your property management and how you should think of the contract.
Great. So I see we have a couple questions. Very quickly, I don't know if this is a glitch on my end. I see a handful of attendees whose names are my name. So I'm not sure if just it's a weird Zoom fluke. But if you happen to see that your name is listed as Leah H, would love for you to update it so I, can see who all of our attendees are. Uh, all right, let's jump into the questions. So one of the Leahs, mentioned regarding the pilot training program, if we opt into it, can we choose the course curriculum?
The answer is not you specifically. There is a committee of people who are already on the advisory council of the training fund who are going to select the curriculum. But if you do have suggestions or things you want to see, by all means, send me an email, send an email to an attorney at the RAB. We will pass them along. We are taking suggestions.
Great. Another question. Were wages increased for live-ins in superintendents or resident managers?
The answer is yes. We negotiate the resident manager agreement at the same time that we negotiate the apartment building agreement. And, there's this weird distinction here where if you have 5 or less employees in the building, including a super, he's under the apartment building agreement and his raise goes into effect April 21. But if you have more than 5 employees in the building, including the super, then he's under the resident manager's agreement. His raise goes into effect June 21. So all of them had raises that were negotiated in this agreement. There are essentially differentials that are built in. There's a 5 cents an hour differential from the door person and handy person wage rate to the handy person wage rate, 5 cents an hour. And then there's 7.5 cents an hour from the porter door person wage rate to the new super resident manager wage rate. But if you have a question as to whether you have a resident manager under the resident manager's agreement or a super under the apartment building agreement, call the RAB. We'll work you through it.
Great. Another question. We have a 30+ year super. We pay all salary and benefits plus his apartment electricity. He makes money on the side apartments too. What's the building's responsibility to give the super? It's very expensive. We have a union porter. There's no job description. So I feel they don't do much for the cost.
I mean,
So
it's a
big question.
complicated answer is, look, not every super is in the union. There is no requirement that they be in the union. Sometimes they're what's called statutory supervisors, which makes them management and pulls them out of the union contract. The vast majority, though, in New York City are in the union. And look, it is expensive. There is no way around it. They get, the apartment, they get the benefits, they get, plus, plus, plus to be able to work in the building and be available to the building around the clock, essentially, in case of emergency. And, you have to increase them by the minimum amount in the contract, but you don't have to give them more than that, is what I would say.
Hope that was helpful. And then next question, what's the new wage for the security guards and when does it start?
It is the same as the RAB security officers agreement wage rate. And I just don't have it in front of me at the moment. If you want to shoot me an email after this, I'm happy to go look it up for you and shoot it back to you. But it is higher than, I think it's 19 and change. Just don't quote me on that for a security officer 1 under the agreement. And I believe it goes into effect January 1 of 27.
That was also asked by another Leah. So if I knew who that was, then I could reach out to you directly on that. Next question. Do you know when contracts will be posted on the 32BJ website?
That's always a good question. After we reach the agreement, we now have the Herculean task of integrating the contract, meaning we have to take the old contract, we have to write all of the new language changes into it. Then we have to go back and agree on that. It's usually a process of months, but I'm hopeful that we can have it done in the next, I'd say 6 months. Likely, it'll be posted. And on our bulletin on the REB member website, you see all of the material changes to the contract. So you can run through those with your property manager. If you have any questions, you can always reach out to us as well.
Great. Next question. We have 23 employees, and with this contract, RAB has raised my cost to approximately 103,000 per employee, which is cost prohibitive. Were these calculations done prior to negotiations?
Were they done in the sense that, we knew what it was going to be? No, we model it. Certainly, we do financial modeling of what the cost is likely to be. And we have different scenarios based upon, the willingness of the industry to take a strike, if we're not willing to meet certain wage conditions. And, at the end of the day, we operate within the market and within the broader market of labor building service employees. You may have noticed that the hotel workers, I believe, got massive increases that dwarf the ones that we got.
Yeah, I think this is one of the unfortunate realities of living and owning in New York City is just costs of everything, especially labor, just continuing to go up. We're seeing for the
Yeah.
buildings that we manage, this is likely the one, if not the one of the biggest line items.
Yeah, I mean, we talked about this with the union, how it's become prohibitively expensive just to live in New York, but also to own in New York in terms of, look, labor costs are just one piece of the puzzle. Your property taxes are going up. The compliance with local laws is going up, and those are much bigger expenses, generally speaking, than even the labor costs are. So it's something we definitely are very, very thoughtful about before we engage in negotiations. And if you think that you're experiencing, economic distress or you have too many employees, those are things we can certainly deal with under existing structures under the contract. You have the ability to reduce force if you reduce services. And under certain circumstances, pretty dire circumstances, you can deal with it from an economic basis as well.
And you also mentioned that all of the buildings need to sign the assent. So there's the opportunity to kind of come to the table and continue the conversation, if I'm not mistaken.
Yeah, there are certainly buildings that do that. I don't personally recommend it. It undermines the process essentially of having one party negotiate the master agreement. But look, there are certain circumstances where you have specific building issues you want to negotiate with the union. You need to hire independent counsel, and you need to, tell the union that you want to bargain over that specific issue, and you need to reach an agreement, or you can face a strike.
All right, it looks like we've made it through all of the questions. And oh, hold on. Wait, looks like we've got another one come in. With regard to language in the agreement, if you're empowered to do so, clarity about what defines quote a day would be appreciated. For example, parts of the agreement reference part-time as 20 hours or less. Another part references quote more than 2 days. We're unable to answer if quote day was any day of the week or hours. Would 4 hours be a half day? We were looking at adding a part-time porter to support, but ultimately the lack of understanding of what days refers to.
I mean, look, the designation of part-time and full-time isn't terribly meaningful under our contract. What I would say is what you're looking at is, when do benefits start to accrue? When do I owe contributions for an employee? And the answer is dictated by the benefits funds themselves. That's what you're seeing in the contract. The day is an actual day, any part of a day. If they work 30 minutes or if they work 8 hours, that's a day. Okay. And if they work more than 2 days a week, then they are entitled to health, legal, and training benefits contributions, unless they're vacation relief workers. Okay. And if they work more than, I believe it's 20 hours per week, which is a different designation, they are entitled to pension and supplemental retirement benefits funds contributions. Okay. So there's two sort of scales there. There's the 2 day a week, and then there's the 20-hour a week. So if you want to avoid benefits contributions, you need to stay under those limits. for a part-time employee.
Okay. Hope that was helpful as well. Any other questions, folks? Rob, anything else you'd like to share after all of these questions, if anything else has kind of come to mind?
No, I thank everybody for their time. Look, I realize that not everybody is going to be happy with the settlement that we reached, but we represent more than 3,000 buildings, residential buildings in New York City. We're doing our best to thread the needle and find a settlement that will hopefully work out to everybody's benefit and avoid a strike.
All right. Thank you so much for joining us. Thank you, everyone, for joining. I hope this was helpful. As we said at the beginning, your property managers should be leading the efforts here to make sure that your building is making the adjustments and making sure that any of your union employees are getting paid based on the new wages and updates to the benefits. If you haven't heard from your property manager about this, you should reach out to them. We at Daisy are also happy to help however we can. And I hope you enjoy the rest of your day. Thanks, everyone.